All right, a federal judge just moved in a direction nobody inside that administration was prepared for. Not a warning, not a preliminary finding. A targeted, documented, procedurally precise judicial action aimed at the structural core of how this DOJ operates. And the Trump team's response in the first 48 hours wasn't a counteroffensive. It was silence. Strategic, deliberate, and telling silence. I've been inside the filings since they surfaced Wednesday morning. The language on page 22 required 4 reads. Not because it was ambiguous, because it was that unambiguous. And the cable coverage is treating this like a political story when it is fundamentally a legal one, with legal consequences that don't dissolve when the news cycle moves. Here's what nobody is saying clearly enough. This isn't a warning shot. The warning shots happened. 3 of them. Over 6 weeks. This is the shot that lands. And Pam Bondi is now inside it structurally in ways that personal loyalty to the administration cannot resolve procedurally. Quick context first. Bondi came into the Attorney General role with a specific institutional mandate, not the one on paper, the functional one. The mandate was to transform the DOJ from an institution that operated on independent legal judgment into one that operated in coherent alignment with the administration's political objectives. That's not editorial framing. That's the operational reality that multiple former career DOJ attorneys have described on record. The appointment wasn't about legal management. It was about legal direction. Federal courts don't usually get to examine that directly. The appointment authority is executive. The operational latitude is broad. Prosecutorial discretion has constitutional protection that runs deep and runs back decades in Supreme Court doctrine. But something changed inside this proceeding. Something that moved a judge who had previously ruled twice in the government's favor into issuing an order that the Trump team's own legal architects were not prepared to answer in real time. That something is what I'm going to take you through. The timeline first, because this didn't arrive on Wednesday without a history. 14 weeks ago, a coalition of state attorneys general filed the original action, not on a single policy, on a pattern. Their theory wasn't that the DOJ made a wrong decision in one case. Their theory was that the DOJ had systematically substituted political direction for legal judgment across a defined category of enforcement matters. 14 months of decisions. 27 cases. A documented progression from policy reorientation to something more rigid, more directed, more insulated from internal correction. That's a structural claim. Courts don't like structural claims against the executive branch. The first 2 rounds of briefing showed exactly that. The judge dismissed 2 of the coalition's 3 lead theories at the motion to dismiss stage. He didn't entertain the most aggressive framing. He wasn't going to be a vehicle for political opposition dressed in legal language. He said that explicitly in his written order at the motion to dismiss stage. He was precise about what he was keeping and what he was discarding. The theories he kept were narrow, but they were the ones with evidentiary traction. 9 weeks ago, the judge ordered sealed discovery. That's the moment the trajectory of this case changed, and almost nobody outside the legal community noticed. Sealed discovery directed at internal DOJ communications, not external briefings, not press releases, not the public-facing legal positions. The internal strategic communications among senior leadership about how to approach cases in the affected category. That order was fought. Hard. The DOJ filed 3 separate motions to limit the scope of that discovery. 2 were granted in part. 1 was denied in full. The one that was denied in full is the one that mattered. The order compelling production of senior leadership communications during the relevant operational window. Those communications were produced to the court under seal. Reviewed privately, not by the coalition's attorneys, not by the public, by the judge, personally, in chambers. 6 weeks ago, the coalition filed a supplemental brief, 53 pages. Public version has 19 pages of redactions, which means 34 pages of that brief contain material the court determined was sensitive enough for restricted disclosure. 34 pages out of 53. That ratio doesn't happen on procedural grounds. That ratio happens when the underlying material describes conduct the court wants to control carefully. 3 weeks ago, a closed hearing. No public access. The docket shows the session ran 5 hours and 40 minutes. That is not a scheduling conference. That is not a procedural management hearing. A 5-hour and 40-minute closed, proceeding on a matter where the judge has already read sealed communications from senior DOJ leadership, is a substantive event. Something happened in that room that shaped what emerged Wednesday. Wednesday's order dropped at 9:47 in the morning. 44 pages. Dense, structured, architecturally careful. Written like a document that already knows it is going to the circuit court and was built to survive that trip. And the word at the center of it isn't aggressive, isn't partisan, isn't inflammatory. The word is calculated. The court found that the pattern of DOJ decisions in the affected category reflected calculated departures from the legal merits of the underlying matters. Calculated. Not careless, not influenced. Calculated. Meaning deliberate. Meaning the departure from independent legal judgment wasn't accidental or incidental. It was intentional. It was the product of a decision to produce particular outcomes regardless of what the legal analysis independently required. That is the most serious finding a federal court can make about the conduct of the Attorney General of the United States. Read it again. Calculated departures from the legal merits, written in a federal court order, attached permanently to a period of DOJ leadership with one person at its apex. Now what the order actually does. Because the finding is one thing. The remedy is another. And the remedy is where the Trump team froze. The court issued a structural compliance mandate. That's different from an injunction against a specific action. A structural compliance mandate doesn't just tell the government to stop doing something. It tells the government to change how it makes an entire category of decisions, to document how it makes those decisions in a format the court can audit, and to demonstrate to the court's satisfaction over a defined monitoring period that the change is real and not performative. The monitoring period here is 20 months. With a mandatory 6-month review and a 3-month emergency review mechanism, the court reserved the right to invoke unilaterally if the documented compliance pattern raises red flags. 20 months of documented, auditable, court-supervised decision-making in a defined category of DOJ enforcement matters. Every decision in that category now has to come with a documented reasoning chain. Not for the public, not for Congress, for the judge, who has already read the internal communications, who knows exactly what the reasoning chain looked like when it wasn't being supervised, and who has made explicitly clear in the language of the mandate that he intends to evaluate the supervised reasoning chain against that baseline. The Trump team froze because there is no clean response to this. The separation of powers argument is real, but it doesn't address the factual findings. The factual findings are in the record, permanently. Disputing them on appeal doesn't erase them. It just creates a second proceeding in which the documented communications are re-examined at the circuit level. Either way, the communications exist. Either way, the judge read them. Either way, the court found what it found. Page 19. This is where the ruling finds its teeth. The court identifies 3 specific internal communications it reviewed during the sealed phase. It doesn't reproduce them. It describes them. The descriptions are careful and deliberate. One communication describes a senior leadership discussion about a pending enforcement matter in which the question under discussion wasn't whether the legal theory was sound. It was whether the outcome aligned with what the court describes as externally established preferences. Externally established preferences. That phrase is now embedded in a federal court order describing an internal DOJ senior leadership meeting. Externally established preferences means someone outside the legal analysis was determining what the outcome should be before the analysis was complete, before independent judgment was applied, before the facts of the specific matter were fully weighed. That is the court saying in careful judicial language that the Attorney General's office was taking direction from somewhere that was not the law. Page 26. The court turns to Bondi specifically, not by name in the operative language. The order is architecturally precise about that, and the precision is not accidental. But footnote 11 on page 26 identifies a category of communications reviewed during the sealed phase and attributes them to the relevant period of senior departmental leadership. It then describes the communications in terms that are specific enough to be identifiable and significant enough that identifying them matters. Senior departmental leadership during the relevant period is not an anonymous category. It has a name at its apex. The court knows that. The parties know that. The circuit court will know that. The appellate record will know that. And the permanent public record knows that starting Wednesday morning. What footnote 11 does is create a factual anchor. It connects the structural findings, the calculated departures, the externally established preferences to a specific leadership window with a specific person responsible for it, without making the ruling personally about her in ways that would expose it to different appellate arguments. The court is threading a needle that shows exactly how carefully this opinion was constructed. A 44-page opinion written by a judge who knew where it was going and built it to get there. That's not a rushed response to political events. That's months of careful judicial work designed to survive scrutiny at every appellate level the government is about to take it to. Now let's talk about what the Trump team's actual response revealed. The DOJ filed a 38-page opposition 17 hours after the order dropped. The internal structure of that brief is the tell. 21 pages on the court's authority to issue a structural compliance mandate against executive branch decision-making. 11 pages on the overbreadth of the remedy. 4 pages on the circuit's appellate standards. 1 page on the emergency stay motion they filed simultaneously. 1 page on the specific factual findings. 1 page. On findings that the court built, over 14 pages of its opinion from sealed communications reviewed in chambers. 1 page trying to address what the judge spent months developing from documents the DOJ itself was compelled to produce. When the most damaging findings in a federal court order get 1 page of factual response in a 38-page opposition, the message is clear. They cannot win on the facts. They are not trying to win on the facts. They are hoping the procedural and constitutional arguments succeed so the factual record never has to be defended on its merits. But the factual record doesn't need a defense for it to do damage. It's already in the permanent public record. The damage is already done. What the appeals court decides affects the remedy. It doesn't affect the finding. Those are different things. And the DOJ's 38-page brief conflates them in ways that sophisticated appellate readers will notice. The circuit court has the emergency stay petition. The timeline matters here because the order imposes a 45-day compliance window for the initial framework submission. If the circuit doesn't move on the stay petition within 3 weeks, the compliance window starts running seriously, and the DOJ has to begin producing documented decision trails under a judicial supervision framework it is simultaneously telling the appellate court is constitutionally improper. That's an operationally impossible position to maintain indefinitely. Either the circuit moves, or the compliance framework gets built under the court's mandate while the appeal is pending. Building a compliance framework under a mandate you're simultaneously calling unconstitutional creates a record that undermines the constitutional argument, because you're demonstrating it's operable even as you're arguing it shouldn't exist. The ones who have been there through multiple administrations, who came in under different political leaderships and stayed because they believed in the institution's independent function. They are now working inside a department a federal judge has found made calculated departures from the legal merits of cases. They have to file briefs in courts around the country. They have to represent the United States. They do it under an institutional cloud they didn't create. When you have spent a career building a professional identity around legal rigor and independent judgment, and a federal court issues a finding that the institution you work for substituted externally established preferences for independent legal judgment, that isn't an abstraction. That is a statement about the environment you've been operating inside. And it creates a question about every decision you participated in during the relevant window, even the ones where you pushed back internally. Even the ones where you flagged concerns that got routed around rather than engaged with. That's not political commentary. That's what institutional findings do to the people inside the institution who kept their integrity intact while the institution was losing its own. The retention problem inside the DOJ right now is not a future risk. It is a present reality. Career attorneys don't announce their departures in political terms. They leave for other positions. They move to private practice. They take academic appointments. The departures are visible if you're watching the personnel announcements, and they've been accelerating since October. What Wednesday's order does to that pattern is not additive. It's multiplicative. Because now there is a documented, permanent, publicly available judicial finding that names the institutional failure those departures were responding to. The case is directly affected by the structural mandate. A judge who took the time to read 44-page opinion worth of sealed documents and write 44 pages about what he found is not a judge who will accept theatrical compliance without comment. The third-party monitoring organization that entered the related conflict proceedings has now formally announced it will file in this proceeding. Its public statement commits to tracking compliance using FOIA requests, public record examination, and information from current and former DOJ personnel. If its monitoring produces documented evidence of nominal rather than substantive compliance, that documentation arrives on the court's desk as the 6-month review approaches. The court will have the DOJ's compliance record, its own direct oversight assessment, and independent third-party monitoring documentation. All simultaneously. All evaluated against the baseline of what the sealed internal communications showed. Bondi's public response since Wednesday has been controlled in tone and limited in substance. The administration's external messaging has treated this as judicial overreach into executive authority. That framing serves the separation of powers argument on appeal. It does not address the factual findings. It is not designed to. The audience for that messaging is not the circuit court. It is the political base that expects defiance of what it characterizes as hostile judicial interference. But the circuit court is not that audience. The circuit court is reading the 44-page opinion. It is reading the sealed record. It is reading the former Republican Deputy Attorney General's brief, explaining why the mandate is constitutionally sustainable. It is evaluating a government emergency stay brief that spent one of its 38 pages on the core factual findings. Those are different audiences requiring different arguments. The administration has chosen to run a single message for the political audience. The circuit court will evaluate what the legal argument actually contains and what it conspicuously doesn't address. Here's where everything actually stands right now. A federal judge issued a finding that the United States Department of Justice, under Pam Bondi, made calculated departures from the legal merits of enforcement decisions based on externally established preferences documented in sealed internal communications. He imposed 20 months of structural compliance monitoring on a defined category of DOJ decision-making. He stayed 4 specific matters pending a 45-day compliance framework submission. He built mandatory review mechanisms into the mandate that will run on a documented baseline drawn from the communications themselves. Bondi's name doesn't appear in the operative findings. It appears in a footnote that functions as a permanent factual anchor, connecting the structural findings to the specific window of her leadership. That anchor is in the public record. It does not require a criminal referral to operate. It operates by existing, by being cited, by becoming the reference point every oversight proceeding touches when it examines DOJ conduct during that window. The DOJ's response brief spent 1 page on the facts and 37 pages trying to find a procedural door that isn't sealed. When the entire strategic posture of your opposition is procedural, you've already conceded that the factual finding can't be defended. You're hoping the appellate architecture gives you an exit before the defense is required. The former Republican Deputy Attorney General's amicus brief closed that hope considerably, because it removes the government's ability to characterize this as partisan judicial interference. When your own side's former senior leadership is filing briefs saying that constitutional authority for this mandate exists, and your emergency stay brief didn't engage with the precedents they cited, the separation of powers argument has a real problem at the circuit level. 45 days to a compliance deadline that the circuit court has to interrupt before it matters. A monitoring period of 20 months covering a category of decisions made by people who now know what judicial access to their internal discussions produces. A permanent factual record in a federal court order connecting the period of Bondi's leadership to findings of calculated departures and externally established preferences. And a judge who built a 44-page opinion knowing exactly where it was going and exactly how it needed to be constructed to get there. This isn't a warning. The warnings happened. The 3 preliminary rounds happened. The sealed evidentiary phase happened. The 5-hour closed hearing happened. All of that built to Wednesday. And Wednesday built to the 45-day window and the 20-month clock and the circuit petition that has to move in the next 2 to 3 weeks to matter before the compliance framework becomes operationally embedded. The endgame phrase isn't dramatic framing. It's the court's own logic made visible. There are no exits the judge hasn't already identified and sealed in the language of the mandate itself. The compliance path is monitored. The appellate path is documented against a sealed record that travels with the appeal. The delay path runs into the 45-day clock. And the defiance path is a different category of institutional confrontation that nobody inside that legal operation is prepared to recommend. When all the exits are closed, what's left isn't a choice between options. It's a reckoning with what the record already shows. The Trump team froze because they read the same 44 pages everyone else read. And on page 19 and page 26 and footnote 11, they found what the judge found when he read the communications they produced under seal. They knew what was in them when they produced them. Now the judge, the circuit court, the permanent public record, the 380 years of combined former DOJ institutional service, filing amicus briefs, and every oversight proceeding that touches this window for the next generation of federal law enforcement history all know it too. The clock that started Wednesday doesn't stop because the administration treats it as illegitimate. The judge built it to run regardless. 20 months. 6-month checkpoint, 3-month emergency mechanism, 45 days to a compliance framework. I'll be in the documents. Subscribe and turn notifications on, because this moves when the filings move, not when the coverage catches up. Right now, the filings are running about 3 news cycles ahead of the coverage. The record is the story. And the record is moving fast.